Hi, I'm Matt DeTura, and with me here today is Komal Jain, counsel at Keller and Heckman. As summer is upon us, birds are in the air, so we're here today to talk about the effect of the FCC's proposed new rules regarding communications towers and bird migration. Komal, can you give us a little background on some of the legal issues surrounding the Commission and migratory birds?
Sure. This all began in 2002 when the American Bird Conservancy filed a petition with FCC asking the Commission to take further steps to protect migratory birds, particularly in the Gulf Coast region, from possible collisions with communication towers. The American Bird Conservancy was concerned that certain towers were located in the actual migration routes of birds and causing avian fatalities. And the petition complained that the FCC's rules regarding tower sightings did not comply with the National Environmental Protection Act and the Endangered Species Act. 4 years later, the Commission dismissed the petition, saying that it would address migratory bird issues in another docket. In response, ABC appealed the decision to the D.C. Circuit Court of Appeals, and the Circuit Court agreed with ABC and ordered the Commission to bring its rules in compliance with NEPA and the Endangered Species Act.
So here we are 9 years after ABC's initial petition and 3 years after the Court of Appeals ruling, and it looks as if the Commission is finally putting forward some rules.
Well, the FCC has released a public notice. It did so on March 25th, and it provides some draft rules and procedures to, again, bring their current sighting antenna structure registration rules in line with NEPA and the Endangered Species Act.
Okay, so what are some of the rules and procedures that the Commission is proposing?
One of the most significant is an environmental notification process. And that is applicants will need to file prior to actually filing their antenna registration with the FCC. They are going to need to complete an environmental notification and publish that for the public to see and review 30 days in advance of the antenna registration.
All right, so right off the bat, these new rules are going to add 30 days to the tower registration process.
That is true. Additionally, what I should have noted is if you have a structure that is greater in height than 450 feet, you automatically also need to complete an environmental assessment. So upon the public reviewing the environmental notification, they can also comment to the Commissioner that they would like an environmental assessment completed regardless of the height of the structure, and then the Commission must take that into account.
Okay. These sound like big changes. From a practical perspective, what are these rules going to mean for companies that are looking to build towers?
It means a lot more time, a lot more resources. They will need to take into account the 30 days to complete the environmental notification and provide for the public comment. And if an environmental assessment is required, that does take a significant amount of time to complete.
It sounds like a lot more paperwork for the Commission, too.
It will be.
Okay. Well, it sounds like something companies with towers should start preparing themselves for then. Thanks, Komal. And for more on this or for any other telecommunications issue, please feel free to contact the link at the end of the video. Thanks for your time.